Good morning. We will come to order for the St. Lucie County Code Enforcement Special Magistrate hearing for October 1st, 2025. Let's all rise and pledge our allegiance to the flag. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The next item on the agenda calls for the approval of the minutes of our meeting September 3rd, 2025. Just one small amendment to be added. In the first section of the minutes, where the cases were either abated, removed, or withdrawn from the agenda, I would add case number 2506, 115, 245. So we'll amend the minutes and I'll approve those minutes as amended for the meeting. Next, Madam Secretary, please swear in all our staff members today.
William Durden, Oscar Moreira,
Paula Guy,
Brian House,
Holly Robertson, Lynn Swartzel, Berlandi Moise.
James O'Connor, Josh
Here.
Morrow.
Do you affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Next item on the agenda, public comments. If anybody from the general public would like to make a statement at this meeting regarding anything but an active case on this agenda, please come forward. Seeing no one, we will move on to the next item, and that calls for new business. Before us, the adoption of the St. Lucie County Rules of the Special Magistrate Hearings. We drafted rules for this hearing so that the general public and anybody involved knows how we do things here. So does anybody want to comment with regard to the rules? If not, I'm just going to adopt them, and they're part of the record.
Approved.
Thank you. Consent agenda, nothing there, so we'll move right on. The agenda has been modified for today and for the future. We will be hearing fine hearings before the actual violation cases. That's the only change, basically, with regard to the order of the agenda. So we'll start with fine hearings. And before we begin, fine hearings are just that, fine hearings. They're not violation hearings. Anybody who has a case in this section, you've already been found in violation. Therefore, basically, what I would like to hear from you are any steps you may have taken to improve the situation and abate the situation and what the status of the case is. But the officers will speak first, the prosecuting officers, and they will give their side of the story and tell me what's been taken. Is the situation the same as it was when the party was found in violation, or were there improvements made? And at what time were they made? So that's the situation on how we handle fine hearings, just for general information. So we're going to go right into case number 2501, 114405. The investigating officer is Paula Guy. The location of the violation is 207 East Arbor Avenue, Port St. Lucie. The property owner, Ella Schwartz. Is Ms. Schwartz here? She is not, but we're going to hear from the officer because I have to determine whether the situation is bad and what steps have been taken, so we do need to hear testimony from the officer in this case. So Ms. Guy, you're up.
Good morning. For the record, all the photos submitted are true and accurate representation of staff's observations on site. 207 East Arbor Avenue was found in violation of Section 7.07.00 Stormwater Management, a failed driveway culvert pipe blocking the county's drainage infrastructure. The requirement is to repair or to replace the culvert pipe and obtain any required permits. The violation hearing took place on August 7th, 2025. The property owner was not present for the hearing, and the compliance date provided for corrections of violation was given for September 4th, 2025. There has been no communication from property owner, and as of today's date, the violation remains in place. Also, James O'Connor from the Water Quality Management Division is here if you have any questions regarding the violation.
Thank you. Mr. O'Connor, would you care to comment?
Yes, sir. Good morning. As of Monday, no action has been taken. Approximately 45 days ago, I did speak with the owner's son, who claims he was unaware that there was even a issue there. He did show up last month, and he did not wait around to be heard at the last month's code magistrate hearing. As of Monday, no work has been done. We spent a good amount of money of our swale maintenance budget in 2025 to repair the areas in River Park and improve the drainage. And unfortunately, this address is still impeding drainage.
Thank you. I believe staff's recommendation is for a fine of $250 with a begin date of September 6th.
That is correct.
And why is that? I'm curious. $250 a day you would like? Okay. In reference to case number 2501-114405, I, as magistrate, make the following determination. After hearing the facts in this case, the testimony, and the report of staff that the violation still exists, and having considered the gravity of the violation, the actions, if any, taken by the violator to correct the violation, and any previous violations, I make the following determination. A fine of $250 per day shall be imposed for each day the violation exists, starting September 6th, 2025, with a maximum fine not to exceed $5,000. Next on the agenda, companion cases 2 and 3. So case number 2406-113-113, investigating officer Paula Guy. The location of the violation, 6900 Heritage Drive in Port St. Lucie, and the tenant there is BMAX Tuning. And we'll also hear at the same time evidence in case number 2406-113-112, investigating officer Paula Guy. 6900 Heritage Drive is the location in Port St. Lucie, and this violation has to deal with the property owner, and that is SLBT Land Holdings, LLC. Ms. Guy, the evidence, please.
Thank you. For the record, all photos submitted are the true and accurate representation of all my observations that were made on site. 6900 Heritage Drive was found in violation of Section 11.05.00, obtaining development business permits. There is no active business permit that has been obtained by the occupant BMAX Tuning business that's on the property. The violation hearing took place on August 7th, 2025. The business and property owner were not present for the hearing. The compliance date for corrections of the violation was given for the date of September 4th, 2025. The business owner has not completed the permit application process required by St. Lucie County, and as of today's date, the violation remains in place. There has been no further communication with the business owner since June of 2025. At this time, the county is recommending a $50,000 max fine for the location of 6900 Heritage Drive.
For both parties.
For both parties.
When were these parties originally cited? You may have said it, but
They were originally cited, let's see, it's missing off the thing. They were originally cited, I think, a year ago. The property, the business owner, he started the application and just never completed it. And it actually went into withdrawn status. So, and I physically have been to the property to speak with him directly, reminding him of the importance. The business navigator has reached out to him. There's just been no good faith effort made. The
So-
case was originally opened in June 7th, 2024.
so they've been operating illegally for over a year.
That would be correct.
Okay. Anything else? Any other comments? Nobody's here representing the alleged, well, not the alleged, the actual violators, as I said. Okay. Let's begin with the first companion of the companion cases. In reference to case number 2406-113-113. I, as
Okay.
magistrate, make the following determination. After hearing the facts in this case, the testimony, and the report of staff that the violation still exists, and having considered the gravity of the violation, the actions, if any, taken by the violator to correct the violation, and any previous violations, I make the following determination. A fine of $250 per day shall be imposed for each day the violation exists, starting September 6th, 2025, with a maximum fine not to exceed $50,000. In reference to case number 2406-113-112, I, as magistrate, make the following determination. Excuse me. After hearing the facts in this case, the testimony, and the report of staff that the violation still exists, and having considered the gravity of the violation, the actions, if any, taken by the violator to correct the violation, and any previous violations, I make the following determination. A fine of $250 per day shall be imposed for each day the violation exists, starting September 6th, 2025, with a maximum fine not to exceed $50,000. Next up, case number 2504-114836. Investigating officer here is Brian Alves. Location of the violation is 1000 Charlotta Street in Fort Pierce. The property owner is Robert Cook. Is anybody here with regard to this case? Seeing no one, we'll go to the investigating officer for testimony.
Good morning, Mr. Krieger.
Good morning.
For the record, I am submitting a total of 11 photos 6 dated 5/5/25, 5 dated 9/8/25. I am also submitting a total of 5 new photos, 5 dated 9/29/25. This case was brought to the August 6th Code Board meeting and found in default violations of 11.05.01, a permit is required for the roof. Number 2, Section 38-26 is for outside storage. Number 3, 38-26 for unserviceable vehicles on the property, a truck. And number 4, Section 38-26 for unserviceable vehicles on the property, a boat and trailer. No one was present to represent the property, and the board gave a default compliance date of 9/5/25, or a $250 daily fine would be imposed. I have had contact with the owner in the past. As of 9/29/25, the property remains in violation.
Thank you. Nobody is here representing Mr. Cook. In reference to case number 2504-114836, I, as magistrate, make the following determination. After hearing the facts in this case, the testimony, and the report of staff that the violation still exists, and having considered the gravity of the violation, the actions, if any, taken by the violator to correct the violation, and any previous violations, I make the following determination. A fine of $250 per day shall be imposed for each day the violation exists, starting September 6th, 2025, with a maximum fine not to exceed, as recommended by staff, of $10,000.
Leave it there. Oh, it's fine.
That concludes our fine hearings. We will now move on to the violation hearings. This first case was continued from the St. Lucie County Code Board meeting on May 7th, 2025. It's case number 2503-114660. Investigating Officer Huskar Morera. Location of the violation, 100 Balsa Road, Fort Pierce. And the property owner is William Braun. Mr. Braun, are you here?
Yes.
Please come forward and state your name and take an oath.
My name is William Braun.
Are you going to speak too, right?
Yes.
Okay, will you
She's my wife, Diana.
state your name and address, please?
Diana Braun, 873 Southwest Madison Avenue, Port St. Lucie, Florida, 34953.
Okay. Raise your right hand, sir. Do you affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. We'll hear from the officer first, and then you'll have an opportunity to address us. All right.
Good
Mo.
morning, Your Magistrate. For the record, I am resubmitting 3 photos dated April 8, 2025, 2 photos dated March 11, 2025, 3 photos dated May 5, 2025, and I am submitting 3 photos dated on September 19, 2025, 1 aerial picture from the property appraiser website, 2 pictures dated on September 29, 2025. During my first inspection, found the property located at 100 Balsa Road in violation for Section 11.0500, procedures for obtaining development permit. A zoning compliance is required to run a vehicle storage business from the property. Section 11.05.01, building and sign permits. Please obtain a permit for the fence and the shed. Section 42-103, payment of tax prerequisites to engage in business. Please obtain a business tax receipt license for the business on the property. I issued a letter on March 12, 2025, and gave a compliance date of March 26, 2025. after getting no compliance, certified notice to appear for the May 7, 2025 Code Board meeting was issued on April 10, 2025. At the May 7, 2025 Code Board meeting, the owner was present and the board made a decision to continue the case for the October 1st, 2025 Code Board meeting. A fence permit FENC-2503-001630 permit for the fence was submitted March 16, 2025, and is currently in review and cannot be issued until after the waiver deferral or the zoning compliance is approved. Zoning compliance application 2503-000465 for the business was submitted March 15, 2025, and is currently in review. There is no permit for the shed on file at this time. I have remained in contact with the owner. As of September 29, 2025, the property remains in violation.
We have two permit applications that are under review.
That is correct, sir.
And could we hear from the building official as far as why we're in that situation? I understand one was contingent on,
Yeah, the fence permit was contingent on the approval of the zoning compliance.
and where are we with the zoning compliance?
Zoning compliance right now is set for requires resubmit, and I think they need to get a development permit for this
That's
from planning.
Did you get sworn in?
I do need to be sworn in.
Yes, go ahead.
Please state your name.
Fondra Lanise, Business Navigator.
Do you affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Yes.
Good morning, Magistrate. Yes, they did submit a waivers, deferrals, and alternatives application in February of this year in order to change the development schedule and phasing slightly. That WDA has been denied, in part because of the code violation that is in effect. So that is interfering with completion of both the zoning compliance and the fence permit. It is not necessary to have that WDA, but without the WDA, it is necessary to complete the required site improvements for the business to operate.
And what kind of site improvements are we talking about?
Primarily paving and access.
Right.
There's also some landscaping as well.
Thank you. This was continued 5 months ago.
Correct.
Yeah. What have you been doing?
Paying the engineer and not getting any response with any emails.
We've been trying to take care of it, but can't get a
We've
hold of
been
anybody.
trying to take care of it,
So-
but nobody will respond to us. So
Let's,
we need a building permit to get a fence permit. We do not need a building. If I put a building on the property, I won't have enough room for storing vehicles. I am one of 10 repo agencies, state licensed in the state of Florida, in this area in St. Lucie County. 2, 3, 4. 4 out of the 10 have no business tax receipt. 10 out of the 10 have no pavement. Nobody seems to bother them, but everybody seems to bother me. So I don't know what else to do.
just give me my fence permit, my shed permit.
Give us our fence permit and I'll use the
Simple
shed
as
as a
that.
building and
It's all drawn up the way it's supposed to be drawn up. The easements, everything's there, the drainage is there,
the only thing that's not gonna
the
be.
base rock is down, everything they
Everything's
wanted is
there.
done except for the
Everything's
asphalt. So let's
And the
just file
asphalt's
the
like
permits and let's get it
$50,000,
done. Let them come out and inspect it. It's
I
done.
mean, we've been Tondra.
Enough
We've
is
been-
enough. I mean, this is getting a little out of hands.
This is every time we move somewhere that we get nothing but heartache. I shut my business down. Because of that.
Yeah, I can't operate there, can't do this, can't do that. Enough is enough.
Isn't there an easier way to do this for them?
Yeah, don't open a small business in St. Lucie County.
As far as,
Sorry.
without the approval of planning, no.
Because last time we were here, they said that you guys were gonna give us a chance and, to make everything right. And we haven't heard from nobody. She's been sending emails, been on the phone with the engineer constantly. The engineer's like, no, we haven't heard from the county building department. No, we haven't heard from these. Why am I paying an engineer and going through all these steps, trying to do the right thing here, if I'm just getting pushed in a corner. I mean, it's not fair.
Have you thought about getting a different engineer?
I owe this one $30,000.
Just to put up
Just for
fence in the
nothing,
shed,
to
and
keep coming before you.
it's just
You put
getting
a
crazy.
lien on the property.
When were they originally cited on this case again?
In March, when we
And
moved
the only
in,
reason why we were cited is because we went to the building department first and
to tell them that we were moving.
that we were moving over there and what we were doing and what we need to do to get it done. So instead of going through it with us and helping us through the site plan or whatever we had to do, it was boom, they sent somebody over to,
And if we would have never had this code compliance violation, we would have got our WDAs.
Your Magistrate, they were cited back in March the 12th of 2025.
Correct. That's when we moved in there. We moved in there March 3rd, 2025.
you know, we're trying to do
We
something.
weren't even in there a week and you were
Hiding
citing
or
us.
anything or doing
But
something illegal.
we've been working on this since 2019. So I can't get my WDAs with an open code violation. I can't get a building permit because I can't afford to put a $40,000
Yeah,
building.
before this case was open, I did contact you guys and make sure I told you not to put up the fence up there because
The
you
fence
need-
was already up.
No, it was not that, so I was.
The fence was already up.
No,
Yeah, the fence was
so.
We put the fence up in February.
Okay, again, before the case was open, I had a case across the street, and I saw the poles on the property before you guys put the sections of wire. And I gave you guys a courtesy call, and I told you, just listen, before you do that, make sure you get a permit.
They
And
they
next
won't
thing
give
I
it
know,
to
the
me
fence was
without a
up.
building
I
permit.
understand, but
Can
you-
I
you-
ask you a question? I've had that business since 2005, and I've supported my family as well as other family members. What would happen if somebody came in and said they're diminishing code enforcement, we're gonna knock you guys down from 30 people to 6, and you lose your job, and you can't take care of your kids?
Well, again, I'm not able to answer that, but I did call you guys and I told you that I gave you the information. Please make sure you get a permit before you continue the building of the fence.
And
you
we
said,
applied for it,
yeah, but you're not supposed to put up the fence without a permit because that's not how it
but I
works.
applied for it, and I tried to pay for it, but you guys won't give me a price.
Well, that's part of the issue too. I mean, it's an after-the-fact fence
So
permit.
then what about these other,
That-
here you go, hold on a second. Here. There you go, no pavement, no nothing. That's one Repo agency.
Excuse me,
Here
but
you
that,
go.
you know,
No
I hate to
pavement.
interrupt you.
They have fence permits.
but a
This
lot-
one doesn't even have a yard, so I don't know what he's doing. I'll talk to the Tallahassee about him. Here's another one, no pavement. Here's another one, no pavement. Here's another one, exactly what we have, 12 inches of base rock. Here's another one, no pavement. No pavement, no business tax receipt, no pavement, no business tax receipt, no business tax receipt. No business tax receipt, tax receipt. I'm doing everything I need to do.
All right. I can only consider the case that is before me, and if other cases aren't brought before me, I cannot consider them at that particular time. All I can look at is your case and whether you've taken steps to comply with the alleged violations.
I have no problem complying with any obligations.
And I have to follow the laws of St. Lucie County.
Okay,
The bottom
but-
line is,
but
we
it's
have,
good. We're
we
not
have a
getting
code, and the code has to be followed. Unless the code is changed by the Board of County Commissioners, my hands are tied. I have to follow the law as it's
So?
written right now. So what I'm going to do is, I'm going to find you in violation in this case. I think continuing it any further is not going to really, based on what I've heard from staff, is going to make much of a difference.
So what am I
Because
supposed to
so-
do? Take the fence down and what?
That's
Do what?
ridiculous.
So
Do
in
you want
order,
me to sign the property over to you? I don't know what to do with it.
Okay, that, we're gonna move on here in reference to case number 2503-114660. I, as magistrate, make the following determination. After hearing the facts in this case, the testimony, and the recommendation of staff with regard to the existence of a violation, I determine the violation in fact did occur, and the alleged violator committed the violation an order of enforcement is warranted. If the order of enforcement is not complied with by November 7th, 2025, a fine of up to $250 per day may be imposed. The cost of $200 is being imposed as the cost for prosecuting this case. Please take notice that on the first Wednesday of the month after the date given for compliance at 9 a.m. or soon thereafter, as may be heard, a fine hearing will be held if the violation is not abated by the given compliance date. Next case, number 2507-115444. The investigating officer is Mr. Morera. The location of the violation is 3008 North 25th Street in Fort Pierce. The property owner is Eric Snow Chiramanca. Yes, sir. Come forward. And did I pronounce your name properly? If not, please correct me.
Good morning. Good morning. Eric Snow Chirumka.
Chirumka. Okay, very good. Please be sworn in.
Can you please state your name and address?
Eric Snow Chirumka, 3008 North 25th Street, Fort Pierce.
Do you affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, Mr. Chirumka, we'll hear from the investigating officer, and then you'll have an opportunity to address us.
For the record, I am submitting 3 photos dated July 21st, 2025, 1 photo dated August 7, 2025, 2 photos dated September the 11th, 2025, 5 photos dated September the 22nd, 2025, 8 photos dated September the 29th, 2025. During my inspection, I found the property located at 3008 North 25th Street to be in violation of Section 38-26, abandoned property, junk, trash, and debris. Please remove or repair the unserviced vehicle. Section 38-26, abandoned property, junk, trash, and debris, outside storage. Section 38-97, prohibited acts, overgrowth. Section 3.01.03, residential single-family -4, commercial vehicles are not permitted in residential districts. Please remove the commercial vehicles from the property is not allowed. Section 8.00.03F, outdoor storage of recreational equipment. Only 2 recreational equipment such as the trailers and boats are allowed on the property. Please remove additional. Section 8.00.03, outside storage of recreational equipment. The recreational equipment such as the trailer and boat must be paved on the surface. Must be on a paved surface to be in the front yard. Please place on the surface and move to the outside or rear of the property. Your magistrate, this section has been abated. He removed the boat from the front of the property. I issued a notice of violation letter on July 22nd, 2025, and gave a compliance date of August 5th, 2025. After getting no compliance, a certified notice to appear for the October 1st, 2025 school board meeting was issued on August 12th, 2025, but it was returned undelivered. A second notice to appear was created and posted on September 11th, 2025. I have remained in contact with the owner as of September 29th, 2025. The property remains in violation.
Thank you, Mr. Morera. Just to make sure, Section 8.00.03, parentheses F, outside storage, you're saying both of those, they're twice on the agenda here for boats and trailers, so are they
So the
all
one,
gone? Which one is abated?
so it's the last one. He had a boat on the front of the property on the grassy area. And in order for the boat or trailer to be parked in the front, it has to be on a paved surface. But that was abated a few days ago when he removed it from the front of the property. So it's the
only
last section.
Yeah, so that's F.
Yes,
You got-
correct.
That's it?
Yes,
All the others are still out there pending?
that is correct, Your Magistrate.
Thank you.
You're welcome.
Yes, sir. Your turn.
Okay.
I'd like to hear what you have to say.
I have some pictures to submit.
Sure, and show them first of all to the county attorney, and then we'll put them into evidence, and then I'd like to see them.
Okay. Yes. 2, 3. Yeah. Okay.
Mark these as exhibits.
I think I'd like to keep one. I was going to give one to Officer Mo.
You could mark them as A, B, C, D.
Yeah, 4.
There's 4 of them. Yeah, let's mark them up. You want to mark them up A, B, C, D, so we don't have any confusion, and we'll put them in the record. Thank you. Did you want to explain these photographs one
Yes.
by one?
Yes. Officer Mo, he contacted me probably 6 weeks ago, said he was at my house, and the front door was open, and that I needed to clean up the property. I had 3 boats in the front yard, and he said that there can only be one, and it has to be in the side yard, and I had the one in the side yard, and the other 2 I had brought up when I was moving and dropped them in the yard real quickly, and was busy doing other things, and one thing led to another, and they sat there for several months. But he gave me, he told me that the place has to be cleaned up. It has to start looking like a normal residence. And I told him, a resident, and I told him that I would be working on that. And he said, if you get it cleaned up before today's date, call me and I'll take a look at it, and we'll go from there. Hopefully close the case. And so I picked away at it, and I got to the point yesterday where you stand out on the road and it's all cleaned up, and the boats are gone. The one that's allowed to be there is there. I cleaned out my carport and pushed the car back into the carport instead of having it out on the front driveway. And I believed that I had come into compliance. And then he informed me yesterday that, no, there's the matter of the backyard. And I was like, the matter of the backyard? I said I was under the impression that code enforcement was allowed to stand on the street and take pictures of your property, but they were not allowed to enter onto your property and take pictures. Whatever they could do from the street, they were allowed to do. But I just saw these pictures that he's taken for the first time now, and 12 of them are
Well, let me ask you first
standing
of
in
all.
my backyard.
First of all, these pictures that you submitted into evidence,
Yes.
when did you take these pictures?
Yesterday,
These are yesterday.
after I talked to him and he said, no, I still had to go to the hearing, I
Yes.
spoke to a gentleman who is a lawyer, and he said, take pictures and submit pictures of the cleanup,
Yeah.
and request that the case be dropped, dismissed. And so that's what I did. I took pictures and had them printed, and he said, take 3 copies so that they can go where they need to go. And then, see what the special magistrate has to say.
Looking at these pictures, it does look like the front has been taken care of. Mr. Moreira, did you look at these pictures?
I did, Your Magistrate. So even if I didn't have access to the rear,
Yeah,
you
how
can
did
tell.
you, how did you get those photos?
So the complainant granted me access to their property, and I just happened to walk to through their property and take pictures of the back of the property.
Oh, Your Honor?
Did you allow Mr. Morera on the property?
No, I did not.
You mean he's
said
not telling the
there's-
truth?
He said there's a
He said the
complainant.
complainant.
Oh, I'm sorry. Okay. I'm sorry, I misheard.
I was
Okay.
not aware of the fact that there was a complainant, and I think that according to the law, I should be informed about the complaint that was registered against me.
Sure.
And I had no idea that somebody complained.
All right, so I understand. So, Mr. Morera, you did not go on the property. It was somebody else's property.
That is
that you took
correct.
the photos from, and you were given permission there.
All pictures were taken from the complainant's property. The only time I accessed his property was to leave my business cards at the door, and that's when I called him and told him that his front door was propped open, but I never took pictures from inside the property.
Okay.
Everything was from the front of all the pictures that you can see from the front of the property were taken from the right of way.
Right, you're all right. You're allowed to do that, of course, under the law. My question is, though, I think the gentleman speaks correctly when he says he's entitled to know who the complainant is under Florida law now.
That is correct. Usually, if it's requested, we can provide it because it's a public record request. But
Yes.
he never provided. He never requested it.
All right, well then, why don't you put in a public records request for the complainant?
Okay.
You're certainly entitled to it under Florida law, and they will provide it, they will provide you the name.
That is correct.
And what I'm going to do at this time is, based on what I'm seeing, you're still in violation, with the back of here. And I'm going to give you a little time to clean this up and find out who the complainant is. All
Okay.
right? And then and then you can see if you can work things out.
Yes, I think I mentioned that I did speak to a person who is a lawyer who's familiar with these types of cases, and he said to, if something if a case isn't dropped today, to request a continuance so that I can, I really do want to, I don't know too much about this, but,
I understand. The law is complicated, and
it's the first time I've been here.
you're certainly entitled.
It's a little bit unsettling, but I do want to come into compliance. And like I said, when I was moving out of my other house, at the same time I sold my house, and then I had to move the stuff from my house, and then the storage area where I had some stuff stored, they went out of business. They sold the property, and I had to move everything so quickly. That's why the boats ended. That's why the stuff ended up kind of haphazardly placed where they shouldn't have been placed.
Right.
So I will do my best once I know what the compliance is that is expected of me. I will do that.
Yeah, and basically, Mr. Morera has basically explained to you, regardless of if you know who the complainant is or not, that's going to have to be cleaned up
Yes.
in the back there. How long do you think that would take you to do that?
Well, I still work full time, so I imagine it would take me probably 2 months.
Yeah.
If I could have October, November, if I could have until the end of the year to clean everything up and have everything gone, I would certainly be able. I would be willing today to commit to doing that, and I believe that it will be done to Officer Mo's satisfaction, and I'll work closely with him so that he can coach me. He's been very reasonable all along. Yesterday when I found out that, no, the work that you've done is not good enough, then I was really shocked and kind of unsettled.
You did take steps to rectify the situation in the front. Mr. Morera, what do you think about the request from the violator getting till the end of the year to clean everything up?
Do you think
tell me what you think.
I think the biggest thing, because I did trying to work with him because due to the lack of progress, I had to move forward to a hearing.
Sure.
But I told him from day one, if you work with me, I'll work with you. I think the biggest thing will be the grass.
Yeah.
That brings a lot of wild animal and affects the neighbors. So if he starts by cutting the grass, I think plenty of time can be given so he can work on everything else.
Yeah, what do you think about getting a mower in there? I mean, you're gonna, that little mower you have sitting out front's not gonna do that.
No, I know. It's going to be an adventure.
Yeah.
I mean,
But I mean, there's so many lawn services in St. Lucie County. I mean, on every corner and they all got the big mowers, you know, these guys.
well,
Yeah, but people are looking for work too. You could, I mean, trust me, they could come in there and knock that out. It wouldn't cost you as much as you think. It just wouldn't. I know that because I have lawn service and I use the guys, and I can't recommend who I use, of course.
No,
but
I know, I
But there
understand.
are so many reasonable people looking for work. I can tell you to do that. And I think Mr. Moreira is correct. I mean, obviously, the animals and snakes or whatever else can get in there. That would affect the neighbors, obviously. All right, I'm going to give you some time to take care of this. You said you thought you could do it within 2 months, and I think that's a reasonable request. Not sure I can take it all the way to the end of the year. Let's see.
the end of the year is 3 months. Starting today, October, and then November, and then December.
Well, it would be, we could take it based on October to November, December, October to November, December.
By the time the fine hearing comes, it'll be 3 months, so.
It'll be 3 months before the fine hearing
Right,
comes.
right.
So, I mean, basically October and November. We could do this, what I'm basically going to do is this. I'm going to give you till December 1st to get this taken care of. That's 2 months. The thing is, though, if you're found in violation, and you will be today based on what I've heard, there will be another hearing. There will be a fine hearing, and you will then get notice to come back, and you can show me what you've done. And then if things are taken care of, and that hearing won't come till another month after that. So you're really getting 3 months. And then basically you can show me what you've done. If you've cleaned everything up, abated, there'll be no fine. Okay. That's what we're going to do here today. I think that's fair and reasonable.
Okay, I
based
kind of
on-
understand. October, November,
Yeah, you got the full month of October and the full month of November to take care of everything.
right.
If
I've
you're
made-
not in compliance, if you've done that and Mr. Moe sees that, case is gone.
Okay.
You never have to come back. It's over.
If
But
I-
if you haven't done it,
If
you
I've
haven't
made a
cleaned it
really
up-
good faith effort and I've been working my free time there and removing stuff and cutting, I'll start by picking away at cutting the grass. Then if I've made a good faith effort and December comes,
or January, you may have the hearing in January. By that time, then if you've done it in a good faith effort, then we may, we'll be very open to whether or not to institute any fine.
okay,
Okay?
all right.
Let's just make your best step.
Okay, I'll
Take your best steps to get this done. Okay? I don't want to continue it. I'm going to find you in violation today. So that gets the clock running. And actually, the reason for that is to put a little fire behind you to get going. Okay?
well, and to be fair
And you
too,
have been. And that's why I'm going to give you the time. But basically, a 2-month extension on the violation is really 3 months. You get what I'm saying? Because the violation hearing doesn't come till a month after that. Fine hearing, I'm sorry. Okay. See, it's a two-pronged thing. You sat here in the beginning.
I watched the.
Those were fine hearings.
Right.
Those people were already found in violation. So we had to impose a fine at that particular time. A lot of them didn't show up, if you saw, and they got hefty fines.
Yes.
Okay? You show up and show me what you've done, who knows what can happen. Okay?
And at that point, you might say, okay, you're like 75% done.
Well, that's not going to be good. I really, by the fine hearing time, I expect you to be done, which would be 3 months. But I'm only giving you 2 months. That's basically giving you what you want. But 75% isn't going to cut it at the end of the year. If you're not done by the end of the year.
Not by the end of
well,
the year.
it's going to be the end of the year.
I know by the end of the year I can
But
have it done.
basically, by the end of the year, you may have to come back here, but you'll be okay.
Okay,
All right.
I'll
Okay.
I'll go along with your recommendation, and I'll be happy to work with Officer Mo.
Work with this guy.
Yeah.
He'll,
He's
but you
very-
got to
been
take
very-
care of this.
Very professional.
You got to take care of this. I wouldn't like it if my next door neighbor had something like that. All right, I'll just be very honest with you.
Okay.
Special Magistrate?
What's that?
Forgive me for interrupting. I just wanted to let Mr. Tramaca know that I've processed his public records request, and if he could wait a few moments, the hard copy document is being brought up to the chambers for him.
Oh, I wrote that down, the public records.
So she's already done that
I've already
for
done
you.
it. If you could
You're
just
gonna
wait
get
a
it?
few moments, and it'll be given to you in your hand.
It looks like she's coming with it now.
Okay, so then
Okay.
we'll move on here. All right.
Thank you.
Okay, thank you, Your Honor.
I have to finish up on your case here, all
Oh,
right?
okay.
In reference to case number 2507-115-444, I, as magistrate, make the following determination. After hearing the facts in this case, the testimony, and the recommendation of staff with regard to the existence of a violation, I determine the violation in fact did occur and the alleged violator committed the violation. An order of enforcement is warranted. If the order of enforcement is not complied with by December 1st, 2025, a fine of up to $250 per day may be imposed. A cost of $200 is being imposed as a cost for prosecuting this case. Please take notice that on the first Wednesday of the month after the date given for compliance at 9 a.m. or soon thereafter as may be heard, a fine hearing will be held if the violation is not abated by the given compliance date. You see what I did there then? You're going to have another meeting if you're not in compliance to see whether a fine is established.
Okay.
Any other questions?
Is $250 a day,
That is what the law allows, that I could fine you up to $250 a day. Doesn't have to be that, but that's the maximum. I didn't fine you anything today.
Right.
I just did though impose a cost for prosecuting this case because that takes staff time,
Oh, yeah. Oh, no, I understand
and that's
that.
$200.
When do I have to
And
pay
as a
that?
matter of fact, I'm gonna tell you, because you've taken an effort and cleaned up the front, let's modify that with the cost of prosecution being $100, okay?
Okay.
So it'll be $100, and you can make payment to the code enforcement office?
Paula?
Go ahead.
Yeah, that would be correct. He can make payment at any time to the code enforcement office.
Anytime.
Can
When
I do
just-
it after my Social Security check comes?
Yeah.
Yeah.
You don't have to do it right now.
do it today, right?
Absolutely not. no.
Absolutely not.
okay.
No. Yeah,
Okay.
typically, someone will pay it within 30 days.
Yeah. But we'll give you, when you get, you pay
Okay,
it
I
in
can do
next-
it within 30 days.
Yeah, then pay it. It'd just be $100, all right?
Okay.
And that's for most time in the county. We have to look out for the taxpayers too.
Oh, I
Okay, which you are one of them.
Right.
Okay.
Okay, you're
All right, so it'll be $100 for the cost of prosecution. All right, my friend.
Okay.
Good luck, and I think you'll be able to get this all resolved.
I do too.
Okay.
Thank
Very
you
good.
very much.
Oh, you're welcome. Thank you. Number 3, case number 2507, 115-505. Location of violation, 5709 Eastward Drive in Fort Pierce. And the property owner, which was WJHFL LLC, WJH LLC, has abated the situation. So we want that on the record. And so we don't have to hear that. They took care of the violation.
No, I don't think so.
Case number 2507, 115-401. Investigating officer is Josh Guevara. Location of the violation is 3601 Avenue S, Fort Pierce. The property owner, the the agenda isn't really correct. The, of public record, the property owner is Affordable Housing of Florida LLC, and that's how everybody was notified, right?
That is correct.
So Affordable Housing of Florida LLC is the alleged violator. So is there anybody here representing that organization? Mr. Hatfield, I believe, is one of the representatives. He's not here. All right, well, we'll go forward, and then we'll actually move on and treat this. If they do not show up when we sound the halls, we'll find them in violation. But they were notified in a certified mail, and I believe so.
Yes, sir, that's correct.
Frog in the throat this morning. Okay. Case number 2504, 114833. Investigating officer is Josh Guevara, and the location of the violation is 4000 Avenue L in Fort Pierce. The property owner, Marie J. Baptiste Franz Duval. Anybody here for that case? And we will move on. Case number 2508, 115506. Location of violation, the vacant lot across from 3601 Avenue West, Fort Pierce, Florida. The property owner is Juan Carlos Vasquez Canto. Nobody there either. Nobody here. Mr. Guevara's having an easy morning. All right. Case number 7, 2507, 115412. Location of violation is a vacant lot next to 1309 Easy Street. Property owner Antonio and Maria Rodriguez. And this case has been abated. Case number 2508, 115615. Location of violation 4810 Sunset Boulevard in Fort Pierce. The property owner at the time was Amanda J. Tejens, but this is being removed. We understand there's a new owner of the property. Case number 2507, 115479. Location of violation 110 Banyan Drive in Port St. Lucie. Property owner Jamie Rolando Aguilar and Sandavi Dorantes. Are the property owners here? They are not. Then we'll move on. Case number 2502, 114600. Investigating officer in this one will be Paula Guy. Location of the violation is 3606 Avenue O in Fort Pierce. And the property owner is the estate of Robert L. Cash. I believe there's a representative.
Yes, Your Honor. My name is Sekou Gary. I represent the estate of Robert Cash.
All right, and you are an attorney?
Yes.
Okay, so he does not have to be sworn in. He's an officer of the court, so he's fine. All right, we'll hear, and you've sat here, sir, you know what we're doing here. We're going to hear from the investigating officer, and then you'll have an opportunity to state your case.
Thank you.
Good morning, thank you. February 24th, 2025, a citizen complaint was received regarding condition of the fire-damaged home and debris that remain on the property. For the record, all photos submitted are a true and accurate representation of my observations on site. There was a house fire that occurred on the property to the main structure on July 4th, 2024. 3606 Avenue O, was found in violation of Section 13.0900. An unsafe conditions of primary residence requires a demolition. And also Section 302.7, a damaged accessory structure of the wood fencing. 38-97, prohibited acts of overgrowth of high grass and weeds. 38-26, abandoned property, junk, trash, and debris for the prohibited storage outside. And 38-24, abandoned property in county right-of-way for debris being stored in the county right-of-way needs removal. In March of 2025, the building official requested an emergency order for demolition and lot cleanup. It was put on hold while location of the family was attempting to correct the violations. Contact was made with the family members of the deceased property owner in April of 2025. Over the next several months, the county provided extensions while working with the family while the representative was obtaining probate for the estate property. On July 24th, 2025, a notice of violation was issued, and the notice to appear was issued on August 12th, 2025, with service for today's hearing completed by certified mail on August 25th, 2025. As of today's date, the property remains in violation. The property owners' representatives have been in communication with us for their progress of obtaining legal ownership to correct the violations.
Thank you. Counsel?
Yes, thank you. Yes, I was hired maybe around July by Geraldine Cash and made aware of the violations in the property he was having. I was hired to open the estate, and we filed to open the estate, and we just recently filed a oath of acceptance, which I think is the last step we will need before getting the letters of administration. I've talked with the county about the problems. When I first talked to Ms. Cash, she told me that there was just, debris and stuff like that had to be done. And when I actually talked with the county attorney, they notified me that an actual demolition needed to occur. And that, the county was looking at doing it, and if the county did it, it would be at a cost more than it would be privately. And I tried to come up with a solution for it. And my idea was that the property is going to be sold. So if we could pass really that cost on to the purchaser of the property, or put it into the deal that demolition is a part of it, and instead of my client having to advance that cost now, we can put together a deal where it's understood by any buyer that demolition has to occur within so many days of the purchase, and we can maybe get an estimate for what that's going to be, and that can be, paid at escrow, or whatever way we can work it out where we can kind of get it all done upon the sale. Now, I would have been on this earlier. I had around August 1st, I had an emergency medical situation, so I hadn't. The county had reached out and stuff, but for a while I was a little bit out of commission. I was fortunate enough to receive a kidney transplant, but unfortunately I had a few complications with that kept me up in Jacksonville at Mayo for a little while. So when I get out and stuff, I have been in communication with them, and we do expect to get the letters of administration really with any day now, within a week or two, hopefully. After that, I would have to do a personal representative deed to put the property in Ms. Cash's name and get it recorded with the Office of Statistics, and then at that point we can put the property on the market. From the time that I filed for the estate, we had these people sending me letters, making offers on the property, things like that. So I do think it will sell between. If you're looking at Zillow and Redfin, the property is worth somewhere between $80,000 and $180,000 and $196,000. I think the county tax records has it assessed at $193,000. There's not a mortgage on the property, so there is enough money there to pay for any demolition.
No mortgage on the property, is that what you said?
I don't think there's no mortgage on the property. So there's money there to make these corrections. We just asked that we could do it through the sale, and I know that
I understand.
But we can't pinpoint a time, but I think it will sell quick because from the time that I filed for the estate to be opened, people started sending letters trying to buy the property. I know Ms. Cash has been approached personally by some people, so I don't think it'll take a long time for the property to sell.
You said a personal representative's deed when she gets her letters. Was there a will in this case?
No.
So she doesn't have the authority to sell unless she gets a court order,
Right.
which you could get. How many heirs are involved?
She says she's the only one. She's the only biological heir. I think her father did. After he divorced his mother, she lived with another woman that already had children. That he called his children, but they're not biological children, so she would be the only one.
And he wasn't married to that other woman?
He might have married this other woman.
When do you anticipate the letters? She's filed a petition for formal administration?
Yes. And she-
Okay, and then did she get any, waivers signed by the other parties?
No.
The judge may require that. I'm not going to get into your particular case. I know a little bit about probate. But, that could slow up issuing of the letters. But if you get the letter, she already signed the oath of a personal representative?
Yes,
That's
she
been
signed it.
filed?
The oath has been filed.
Okay. So you've gone down the checklist that the judge requires
Yes.
for opening a formal administration. You filed that yet? With a letter to the judge and a proposed order?
We haven't seen a proposed order, no.
For the letters, you have to do that, obviously. And the judges are pretty quick here if you get all that information in. So you're optimistic that you can get the letters within the next month?
Yes, I am.
And you'll need an order to sell the house
Yes.
to get that, because if there was a will and the PR was given the authority to sell property, then that wouldn't be an issue. But since they died intestate, then obviously you'll need a court order for that as well. And you know this, but I'm thinking in my head as far as how long that's going to take to get all that done. And that could take a couple of months. Getting it on the market, then, you obviously would open up an estate account and move the money into there. And then I'm trying to think then, obviously, at that point, the personal representative is given a lot of leeway then on what to do with the property. So if you sell the house, and then you could certainly at the closing statement take the money out for demolition. Everything you said is certainly possible and well thought out. I know you're in a difficult situation doing this case, because I believe there was a tragic beginning for all of this. All right. I'm going to find the estate in violation. May as well just do that. And then what's going to happen is then conceivably you'll have the house on the market, and if there is a fine hearing, you certainly can return and show me a contract for sale and purchase and what's going on, and then we can take a look at that and decide what kind of fine the estate should incur.
Okay.
And then that could be certainly, any fine could certainly be deducted out of the proceeds from the sale as well.
Surely.
Okay. All right. Anything else, staff? Okay.
No, nothing else.
Nothing else. I'm looking at, we're looking at a couple of months to get this thing done.
Yeah.
And they are taking the proper steps. And if we get the personal representative appointed, then they can do things. They can't do anything until that personal representative is
Correct.
appointed.
The county would like to see more of an effort of the cleanup of the debris and the overgrowth that's there.
Right.
I think there's another issue
And that's
here.
a difficult situation, though, because there is no technical personal representative to take care of the property. I mean, but I would think that the petitioner could certainly take some steps now, I would think, to get the property cleaned up more.
Okay.
I think
She
there's
wouldn't be
another-
precluded from doing that. If she is the biological daughter, I think that would be fine.
Magistrate, I think there's another issue here. That, I mean, you got the issue of health and safety. I mean, it's not just, putting it on the market to sell it or whatever. I understand that's what you're trying to do, but you have a piece of property that is in such disrepair that it's kind of like an attractive nuisance to the public for somebody to get inside there and get hurt. And then you're looking at another lawsuit for somebody getting hurt on the property. I mean, the property would have to be secured. I mean, it's either demo the structure or secure the property.
What does it cost, ballpark, to demo a property like that?
I couldn't
Anywhere
begin to
from-
fathom.
Anywhere from 40,000 up. That's just a declaration of a estimate
Right.
from previous
And Ms. Cash,
cases
your
in the
client,
last 12 months.
does she have funds to advance that she could be reimbursed from the estate? Because that's what could happen. She could do it and then get reimbursed. That would be certainly a reimbursable expense.
I'll check with her, but if not, then maybe if the county demoed it and it could be paid out of the estate. But I'll ask her.
Well, the
first.
county could certainly demo it, and then there would be a lien on the property. And then when it's sold, the county could come in and take that money right out before you disperse any funds. I mean, that certainly would, if that, the lien's there on record from the county.
I mean, worst case scenario, if she can't do it.
If she can't do it, then what does the county say? I mean, basically, you could advise the county
Yes, yeah, definitely.
that she can't do it, and then what steps should we take then?
We would file another notice of intent to demolish and go through all the legal postings.
And how long would that take?
Typically, it's 30 to 45 days before I can obtain a vendor after, the legal postings and things of that nature, notice is given.
Okay. Okay, well, you should have a good idea, first of all, if she's going to be appointed personal representative within the next month. And then whether she can, because if she is and has the letters, then she could advance the money and certainly be entitled to reimbursement. If she can't do that, then we have to go forward with demolition, and then there would be a lien on the property,
Well,
which can be done.
Well, I can find out very shortly if she'll have the money
Right.
to do that.
All right, well, what we're going to do is then, I'm going to find this property in violation. The estate will be found in violation here. And then if she can't do it, you should notify Ms. Guy right away. And then what we're going to do is then set it for another hearing, and she'll go ahead with the notice for the demolition.
Okay.
Okay. Anything else? The staff certainly makes a good point about danger to the community. What do you think about giving them 60 days to see if we can get all that done?
Yeah, I think.
Well,
that-
because what would happen is, if we do the 60 days, I'm just thinking out loud, and please, I'll take your input on this. He'll know, you probably should know in a week or so whether she can advance the money. You should know within a few weeks whether she's going to be the personal representative.
Correct.
Okay? You tell Ms. Guy that doesn't look good. She could right away then, even before we impose a fine, go ahead with the notice of intent to
Yeah.
Correct.
demo, right?
Even if 30 days was given, the fine hearing wouldn't even be on the table until December.
Right.
So, at that point,
Yeah, I get it.
yeah.
I get it. Okay. Yeah. Okay. Because I know the default date was November 7th,
That's correct.
Right, but council should get the benefit of the doubt for showing up, so I'll go a little longer than that. Not going to do a default date. All right. In reference to case number 2502 114600, I, as magistrate, make the following determination. After hearing the facts in this case, the testimony, and the recommendation of staff with regard to the existence of a violation, I determine the violation in fact did occur and the alleged violator committed the violation. An order of enforcement is warranted. If the order of enforcement is not complied with by November 17th, 2025, a fine of up to $250 per day may be imposed. A cost of $200 is being imposed as a cost for prosecuting this case. Please take notice that on the first Wednesday of the month, after the date given for compliance at 9 a.m. or soon thereafter, as may be heard, a fine hearing will be held if the violation is not abated by the given compliance date. And that would, Ms. Guy, make the fine hearing would be the December meeting.
Yes, that's correct.
Right, with the November 17th compliance date. Counsel, you know basically what you got to do with your client, right?
Yes, I do.
Okay. I wish you well, my friend.
Okay, thank you so much.
And medical science is fabulous, isn't it?
Yeah, it's a
I'm
wonder.
looking at you, you look great.
Thank you. Thank you. All right.
Okay,
Thank you.
take care.
Thank you so much.
All right, let's sound the halls and do the
Yes.
defaults.
Thank you.
All right, and we'll move right along here. Case number 2507-115401. Location of violation 3601 Avenue West in Fort Pierce. The property owner is Affordable Housing of Florida, LLC, with a post office box address in Fort Pierce, Florida. Next case, 2504-114833. Location of violation, 4000 Avenue L in Fort Pierce. The property owner is Marie J. Baptiste Franz Duval in Lake Worth. Case number 2508-115506. Location of violation, this is a vacant lot across from 3601 Avenue S in Fort Pierce. And the property owner here is Juan Carlos Vasquez Canto. Case number 2507-115479. Location of violation, 110 Banyan Drive in Port St. Lucie. Property owner, Jamie Rolando Aguilar, and I believe probably Sandy V. Dorantes in Port St. Lucie at the same address. I believe I covered all the defaults, correct?
That's correct.
Have the halls been sounded?
Yes, the halls have been sounded.
In reference to the cases that I just read into the record, I, as magistrate, enter an order finding the alleged violators are in default as they did not appear to protest the violations against them. And I adopt the recommendations of staff as set forth on today's agenda. That's it.
Thank you.
Let's see, I believe no rehearing or reconsiderations at this date, no repeat violations, nothing to refer to the Board of County Commissioners, no fine reduction hearings. Any other business?
There is no other business at this time.
Any staff business?
No other staff business at this
No, and I
time.
understand the amnesty program has expired now? Is that it?
Yes,
Okay. And I have some orders here that I will review.
and I'll have a couple more
And you'll
that
have some more,
were,
so-
that were sent in yesterday.
So how
with the
successful
deadline.
has it been this go-round?
So far, the numbers, I see a large increase because of the extension that we were able to provide to the citizens. It was very helpful. I had more activity, I would say, in the last 60 days than from the first latter part between April and July.
Very good. Okay. Well, if that's it, we're going to adjourn right now. We're done.
Thank you.